All right, State of Nevada versus William Errico, case number C307611. Counsel, please note your appearances for the record.
Morning, Your Honor. William Terry appearing with Alexandra Marcoux Athman. We'd ask the court to waive Mr. Errico's presence.
Okay, and State?
J.P. Raman for the state. I'd like to compliment Mr. Terry on his decor.
I was going to ask you, Mr. Terry, is that really what your office looks like behind you?
It is, Your Honor.
Well, that's not one of those fancy backgrounds or anything?
No, Your Honor.
Oh, well, I echo Mr. Ramon's statements. That is truly festive, holiday, and beautiful.
Thank you, Your Honor. I hope Mr. Raman is as nice to me as he just was throughout this argument.
All right, we're on. We're looking at defendant's motion in limine to exclude testimony of expert Terrell, or an alternative to limit her testimony. Why don't we start, and then other motion in limine to exclude any testimony or reference to deposition. Why don't we start with the first one, motion in limine to exclude the testimony of the proposed expert Terrell. I've looked at the motion, looked at the opposition and the response. Anything else you want to add, Mr. Terry?
Judge, other than a few comments, I'll submit it on the points and authorities. At page 2 of our factual analysis, we set forth what Ms. Tyrell reviewed, and those include the main police report. When an expert testifies, Judge, it's like a set of building blocks. There either has to be exhibits in the record or there has to be testimony supporting it. I have my doubts that all of the police reports, for example, are going to come in. Likewise, the correspondence with the state bar, the recommendations and other summary documents, and there are others, but I'm taking that directly off of the documents that she submitted in reference to her report. Now, what we're objecting to primarily, Judge, is she gives ethical rulings, ethical opinions. And our position is she's not qualified to do ethical opinions. She's not a member of the prosecuting office of the state bar. She's never been on the Southern Nevada Disciplinary Committee. And additionally, Mr. Raman, I'm expecting, is going to bring in Mr. Hoagie, who's going to testify to certain of the rules. The other thing that we object to, Judge, is the analysis that she did in reference to the guardianship. What she really points to are NRS 159.183 and 159.344. But as Mr. Raman knows, since he served on a committee with her dealing with guardianship, and I think this emanates from a case Mr. Raman prosecuted, the Parks case. This statute, these two statutes were not amended until 2017. Her opinion's based on 2017 law. It's not based on what occurred during the time of the charging document allegations. So she should not be permitted to testify as to what the law says as far as guardianship, because that wasn't the law in 2015, 16, etc. So for brevity purposes, that's our position, Judge. Now, we're either asking that you exclude her or that you limit her.
All right, Mr. Raman, why don't you deal with the last point that Mr. Terry raised first?
Yes, Your Honor, and I think that comes from the defendant's response. So with regard to those statutes, first of all, I did check with Ms. Terrell, and the way that the guardianship court has been working, and she's been practitioner since 1994 in will, trust, and estates, and has done guardianship for the large bulk of that. According to her, that has always been locally how that court functions. PI settlements have to be run through the guardianship court. That's usually a huge source of a ward or protected person's assets, and the distribution of that has to be scrutinized by the court for the benefit of the ward. And with regard to the statutes that Mr. Terry cited as far as them not being in place until 2017, 159.334 was instituted in 2017. 159.183 in large part has been on the books since 2003. And in both of them, still looking to 159.183, it still says that basically reasonable expenses are to be allowed to be paid from the ward to skilled persons such as an attorney. Now, if the guardianship court is never apprised of what Mr. Errico is taking from this personal injury lawsuit, or actually 5 or 6 settlements, or even made aware that there were settlements, that's problematic. And that's why at least Terrell's testimony is relevant, prudent, and still on point, because this has been the state of the law since 2003. And to the first point, I know you asked me to speak to the second first. We do have two people who we've...
Let me stop you there, and let's figure this one out. I mean,
Sure.
If she's relying on, if Nevada Revised Statute 159.183 has been on the books in some nature or another since 2003, obviously don't have that much concern with her relying on the version that was available in 2003. But I mean, her references to 159, is it 113? If that wasn't around until 2017, I mean, if she is going to get into practice in, be relying on practice rather than statute, there has to be something in the record that should have been, that she's got to point to inform Mr. Errico that he's got to run these things through the court before he does them, and
Sure, there's multiple mechanisms under which you would run it through the court. A number of them were breached here. Besides just running it by the court as the person who filed the guardianship, there was no initial accounting done, which would be required within 60 to 90 days of the formation of the guardianship. There were no annual accountings done, where certainly after a year, 2 years had gone by and these settlements had taken place, the court would have been apprised of it. Now, to argue that Mr. Errico doesn't have a responsibility to do that under the accounting, it falls on the guardian, may be somewhat true, but then he didn't supply the guardian, Angela Smalley, with any of the information on the financial settlements to be able to do accountings. So all of that becomes relevant and pertinent. So it's a multifaceted way that the court could have been apprised of all of the money he was collecting on behalf and for the benefit of Wilfred Bosserman, and yet never disclosed to the court, took his fees and took way more than his fees, and the court never finds out about it. So there's numerous ways in which he breached his duties under the guardianship statutes.
well, I mean, I'm going to preclude her from relying in any way on 159.113.
I think you mean 334, Your Honor.
Oh, 334. I'm sorry.
Sure.
334.
And that's fair.
And any reference to 159.183 would have to be the 2003 version.
That's fair also.
And she's going to have to point to either other statutes or, and I haven't gone back over her report in detail, but the other statutes or court orders that issue in such cases as it relates to, Mr. Errico being aware of what he has to report to the court. I mean, I don't have any problem with that. Now, let's go to the first part relating to, I think, the ethics rules.
If I could respond, Your Honor. So with the ethics rules, we, as the court knows, we've already noticed two witnesses as being experts in the rules of professional conduct. Either Bill Petit or Dan Hoagie, some representative of the State Bar of Nevada, has to testify in that role, in addition to laying the groundwork for the correspondence that transpires between Mr. Errico and the State Bar. So that's one. And then we have James Christensen, who the defense wants to take on voir dire at first, but he's been a disciplinary panel member. So I'm not as concerned with Elise Terrell being an expert in the rules of professional responsibility. The only reason I brought it up is because she did note that in her report that certain activities in the furtherance of this would be violations of the rules of professional conduct. But I don't need her to testify to that. That probably would be cumulative.
All right. So then I'll limit her from testifying on that, on the rules of professional responsibility. All right, Mr. Terry, let me come back to you on this. What else do we need to talk about?
On this motion, Judge, nothing. And the only thing I wanted to point out is part of her report did say he not only violated the Nevada revised statutes, but also the rules of professional conduct. But I think Mr. Raman's concession is acceptable, Judge.
All right, that'll be the order then. Let's turn then to the motion to limit exclude any testimony or reference to the depot given by Mr. Errico with Mr. Christensen. Let me hear anything again, got the motion, opposition, and response. Again, let me hear anything further from you, Mr. Terry.
Judge, I'll be brief and submit it on the points and authorities, but the fact of the matter is, one, I didn't see an order in the court record that dealt with this issue before. If there was one, I apologize to the court. Mr. Raman may be right on that the court's already made at least a partial ruling on this. However,
that was my recollection. I didn't go back and pull up the order to make sure it was there, but that was my recollection. I'd already dealt with this.
Okay. But we take a twofold position on this, Judge, which is that obviously Judge Williams sealed the deposition, but he did it in such a way as to seal A and B. B was for the attorney's eyes only. That's never been unsealed. And we just want to make sure that all the witnesses, including Mr. Christensen, understand that that cannot be testified to. And with that, we'll submit it.
All right, Mr. Raman.
And Your Honor, again, I went back and talked to Mr. Christensen after their reply. I looked through their motion and actually attaches the Discovery Commissioner's order. And his recollection in this order kind of cement that I don't see where this thing was ever sealed, period. It looks like it's simply the second version or the second volume of the deposition is something called for attorney's eyes only or maybe confidential, but it's not sealed. And that has a specific legal definition. And if I had known that from the Jump Street, I'd ask for both of them to be admitted because it's not sealed. But I'll just hold to my earlier position where we would introduce Volume 1 in our case in chief, likely with Mr. Christensen. And Volume 2 could come into play if Mr. Errico testifies and it would be used for impeachment, just like the disciplinary agreement with the State Bar of Nevada. But I don't see anywhere this thing is sealed.
All right, are you good with that, Mr. Terry?
Well, our position is it was sealed. However, we accept Mr. Raman's position as far as what's going to occur at trial.
All right. Then that'll be the order of the court. Mr. Raman, why don't you go ahead and prepare a very short written order so that we've got it clear?
Yes, I will.
Now, let's talk, and I hate to talk about this, but let's talk about the trial date, January 25th, 2021. I'm just going to be honest. I don't see that going. We aren't going to be doing trials until the week of January 18 at this moment, because the governor's paused through January 15, and who knows what's going to happen then. And then we only have 2 courtrooms that are outfitted to handle the social distancing necessary, and with other security features with air circulation necessary to allow trials to go on and deal with the threat of the virus. And priority is being given to invoked custody cases. So realistically, that's going to suck up a lot of those courtrooms' time until we get to a point where vaccination has, and hopeful successful vaccination has led to us being able to open up other courtrooms and go back to a more normal jury trial schedule. So let me just ask, have you guys talked at all, or what are your thoughts as far as the trial scheduling at this point in time?
Our position is this, Judge. I don't believe it's realistic that this case would go on the 25th. So,
Well, I agree with you completely. I guess let me turn first to Mr. Raman, since the state is the one prosecuting this. What's your thoughts as far as trial scheduling, Mr. Raman?
We would just ask the court to set it somewhere in 2021 where some level of confidence can be presumed that we may have a trial. That means farther than what would normal be, then maybe that's best. I mean, who knows what goes on when we finally get back to normal, whether jurors are going to have vaccines to sit in the box, who knows?
I concur with 2021, Judge. I would suggest, if it's all right with Mr. Raman, the summer of 21, only for this reason. We've already had multiple cases continued because of the virus. And quite frankly, in a number of the situations, we have very little input as to the new calendar call and trial dates. So if that's satisfactory to the court and to Mr. Raman, that would be my suggestion.
I would even propose the fall. Been a while since we've had vacations, and I'd probably like to take one.
That's fine. Fall's all right with me, Judge.
And can I make one suggestion or oral motion before we talk about trial dates? It may bear some relevance on that. I understand, and it's probably not official, that some departments are going to be shifting. And I would make a request, if possible, if Your Honor could keep this case because you've had a long history with it, versus it getting switched up and somebody having to get up to speed on this. So if that at all affects trial dates, that would be my request.
And I would concur with that, Your Honor. As Mr. Raman just stated, you ruled on every motion in this case.
Well, I'll send an email out to the chief judge who's responsible for these case assignment changes, and I'll see if that's possible, because I tend to agree. I've lived this, but I don't promise anything. Our criminal trial stacks that this department, I assume this would continue regardless of whoever judge got it. We have a criminal stack in August through the first week of September, and then the next criminal stack is October 11 through the second week of November. Is there a preference on either one of those?
The September would be fine.
Agreed.
Well, if we're going to do the September one, it's the last week, it's the first week of September, and to finish that off, we'd have to set trial on August 23. Will that work?
Sure.
All right, let's try August 23.
That would be the trial date, Your Honor?
Yes.
Very well.
Because this case you figured would take a couple weeks, if I remember correctly.
Correct.
Probably about 2. Yeah.
You'll have a criminal calendar call of August 10th, 2021 at 8:30 a.m. Jury trial August 23rd, 2021 at 9 a.m.
All
And
right.
then
You think-
are both motions, are they granted in part, denied in part?
I guess so.
Okay.
I don't think. Yeah, I guess granted in part and denied in part. I mean, if you can prepare a written order covering what we've talked about today, Mr. Raman, just something short, because I think that's really all that's required. We can make sure we have a clean record.
Okay, will do.
And we will file a acknowledgement of the new calendar call date and trial date signed by Mr. Errico, Judge.
Okay, very good. Anything else?
No, Your Honor.
Happy holiday, Your Honor. Nothing further.
All right. If I don't see either one of you between now and next year, happy holidays, stay safe, and best wishes for the new year.
All right, happy holidays.
And to you.